Hi, Gene Zwiebel from Zwiebel Law Group. I get a lot of questions about whether or not a parent is responsible if one of their children gets into a car accident. Well, the short answer is it depends. If the child was driving your vehicle here in Florida, yes, as a parent, you would be responsible, but not necessarily because you're the parent, but because you were the owner of the vehicle. In Florida, we have the dangerous instrumentality doctrine, which means that the owner of a vehicle is equally responsible for any negligence caused by the driver of that vehicle. So if you lend your car out to anyone, including your children, and they get into an accident and are at fault, you could be held responsible. Now, if your child had the car in their own name and they get into an accident, for the most part, you would be protected because you wouldn't be the owner of that vehicle. Of course, there are some circumstances in which that wouldn't be the case, but for the most part, you would be protected. So the short answer is if you own the vehicle, your child is driving the vehicle, you could be responsible. So just make sure you have the proper insurance coverage to make sure you're all protected. If you have any other questions, feel free to give us a call here at Sweden Law Group.